Today's lesson is on Article 3, the judicial branch. Now, scholars, it's sort of rather interesting that you see me dressed like this today. It's a little bit different kind of a day here. But in any case, I'm dressed as George Washington, and I'm dressed as George Washington as president, or at least approaching his inaugural address. So I figured I'd better just mention that to everybody. Anyways, today we're on Article 3, Judicial Branch. Now, fascinatingly enough, just to quickly review, Article 1 deals with the legislative branch, Article 2 the executive, and that indeed the Constitution is our second Constitution. It was ratified in 1787. It goes into effect in 1789, when George Washington, of course, becomes President of the United States in April of 1789. All right, so we have separation of powers, the idea of balancing out power between the legislative and executive. My two other lessons talked to the legislative powers and to the executive. Today we're on judicial. Now, also quickly to review, Article 1, legislative branch, is really the longest between the three. That is the one area that the Founding Fathers had a greater understanding and greater handle on. Because remember, that is the one thing, legislature, that they did have under the Articles. Okay, so today, like I said, we're on the judicial branch. The constitutional provision for the judicial branch provides for a Supreme Court giving Congress the power to establish inferior or lower courts. Now, Article 3 is the vaguest and broadest of the three branches. So, for example, in Article 1, when we look at the legislative branch, the House of Representatives, it does clearly delineate that you have to be 25 years of age, 7 years a U.S. citizen, and represent the state in which you reside. In the Senate, it's very clear, you got to be at least 30 years of age, you got to live in the state that you represent, and 9 years a U.S. citizen. However, in Article 3, there are no age stipulations. Judges are essentially appointed for life, assuming pending good behavior, and by design, the judicial branch is supposed to support a non-partisan feeling. But obviously, judges are human beings, so obviously they do have personal feelings. However, oddly enough, when they are invited in to hear the President of the United States deliver a State of the Union address or deliver any other major speech, you will observe the fact that the justices, whenever all the clapping is going on, and sometimes people will stand up and praise the President for what he's got to say, the bench is silent. They're seated, they're silent. All right. In any case, the Judiciary Act of 1789 established 13 district courts in major cities, 3 circuit courts, and 1 Supreme Court with a Chief Justice, and originally it was 5 associates. Like I said, the judges are appointed for life assuming good behavior. Judges are appointed by the President and approved by the Senate. Again, back to the check and balance portion. Since justices are appointed by a President, long after the President can leave, retire, even be deceased, and that justice continues to exert his own personal ideology on the court. And that's really very important, and we'll talk in a little bit about case studies of this. When John Adams, for an example, in the election of 1800, lost re-election to T.J. Thomas Jefferson, who at this point was clearly an anti-federalist or a Democrat-Republican, Adams, who was a Federalist, was greatly opposed to this. Part of it was because it was a 5-way race with no simple majority in the Electoral College. Nevertheless, Adams, at the very last moment, appointed what we call midnight justices to the high bench. By appointing midnight justices to the high bench, what he ends up actually doing is he leaves his legacy on the bench. And we will talk more about that in a little bit. So what are the powers of the court? Well, they're chiefly involved with interpreting the Constitution, federal laws, and treaties. Justices play a pivotal role in the interpretation. And from the interpretation of the law, you will often find laws redefined or in some cases changed completely. The court can be involved in foreign diplomatic officials. They can be involved in cases that deal with two or more state governments, from citizens of different states, and states or citizens involved in disputes with foreign states. Now, the Supreme Court is fascinating, scholars, because they have two kinds of jurisdiction. The first is original jurisdiction. Now, original jurisdiction is when a case comes directly to the Supreme Court. These can be cases affecting ambassadors or public ministers, or it can be cases where a state is considered a party. In all other cases, the Supreme Court has appellate jurisdiction. Early on, like I said, my dear scholars, when Adams lost the famous election of 1800, he fixed it. What do I mean by that? The last night in office as president, he made several appointments. One classic appointment was the appointment of William Marbury. Now, William Marbury was clearly a Federalist, and this was Adams' way of keeping the Federalist foothold on the court system, even though clearly T.J., Thomas Jefferson, was an anti-Federalist or a member of the Democrat-Republican political party. So Marbury ascends to the court because Adams had clearly appointed him. Thomas Jefferson becomes the president, and William Marbury never gets his appointment letter. Well, his appointment letter, dear scholars, is very similar to when you apply for a job and you get a letter in the mail saying, "We want you, we've accepted you." Well, clearly, William Marbury never got his commissionable letter. Now, Thomas Jefferson appoints as his Secretary of State James Madison, you're right, the fourth President of the United States, and orders Madison, who is a Federalist, not to give Marbury his commissionable letter. So indeed, they catch up with the fact that he was appointed in the last minute. So eventually Marbury learns of this, and he's outraged. So he goes right to the Supreme Court, or asking them for relief. And in the famous case of Marbury versus Madison, the court ruled that the Judiciary Act of 1789 to be partly unconstitutional, and it made the case that the Supreme Court ruling would go forward that an act of Congress, or an act of the President, or a law of the President can be deemed unconstitutional by the High Court. And that becomes very pivotal. Marbury ends up getting his commission, and he serves on the court. So, a little more details on the case. Like I said, can the Supreme Court declare a federal law unconstitutional? The court said yes, it can. And again, this angered President John Adams since he lost to Thomas Jefferson. The previous Congress had been dominated by Federalists. Now, not only the presidency was controlled by an anti-Federalist, but the Congress was too. As a result, President Adams nominated 42 people for Justice of the Peace positions, including that of William Marbury. John Marshall, who was still Secretary of State, had been confirmed as Chief Justice of the U.S. Supreme Court, and he failed to deliver Marbury's commissionable letter. When Jefferson became president, he ordered his Secretary of State, James Madison, not to deliver the commissionable letter, like I said earlier. Marbury and 3 others appealed to the Supreme Court, asking the court to assume original jurisdiction and to issue a writ of mandamus, ordering the Secretary of State Madison to deliver the commissions, including Marbury's, and clearly this ended up happening. It was a really, really serious first case that the Supreme Court looked at, where it made a tremendous impact on the legacy and the destiny of the court. Okay. The second case is Fletcher versus Peck, 1810. The issue here is, can a state pass a law which breaks a contract? Can the Supreme Court review a state law? This actually concerned the Zazu land grant scandal, which existed during this period between Alabama and the state of Mississippi. Now, these acres of land were sold to Ford Land Companies for the sum total of $500,000. The sale itself was accomplished by way of a grant by the Georgia legislature of 1795. However, it was soon discovered that all legislators voting in favor of the grant had been bribed. Many voters were disgusted by the corrupt legislators and enacted a new legislature in 1796, which passed a rescinding act rendering a 1795 grant null and void. What basically came out of this case was that the Supreme Court was capable of developing a contract clause that provided legal protection for business enterprises against the actions of the state. Okay, let's take a look at a third case. Martin versus Hunter's Lessee. It was decided by the High Court in 1816. What was at issue? Can the Supreme Court review and reverse decisions of state courts? Well, the High Court said, well, the appellate jurisdiction of the Supreme Court is over the state courts, and indeed the Supreme Court can reverse the decision of the state court. The fourth case, which is rather significant, is McCulloch versus Maryland. It's 1819, scholars. The issue of the court was, does the Congress have the power to create a national bank? Can the states tax such a structure? Well, the second bank of the United States was chartered by Congress in 1816. You'll recall the first one went belly up. The first one was Alexander Hamilton. Okay, back to the second bank. It had branch banks in various states, including the state of Maryland. Although at the time of the second bank being chartered, many argued in favor of it, the bank soon became unpopular due to mismanagement and corruption. The state of Maryland started to tax the bank. McCulloch, the cashier of the Baltimore branch, refused to comply, and a suit arose in the state court system. McCulloch appealed to the Supreme Court, arguing that the Maryland statute was unconstitutional. The state officials wanted the court to decide and argued that the bank was unconstitutional since it was not, quote, necessary and proper, unquote. Maryland further assumed that as a sovereign state, it had the power to tax, and that its tax on the branch of the United States Bank was simply an example of state sovereignty. From this case, we also get a re-examination of the broad constructionist, broad constitutionalist interpretation of the necessary and proper clause. The significance of the case lied in Congress's ability to use its implied powers. Secondly, the strict constructionist theory, also known as the strict constitutionalist theory, says that Congress may only use powers that are explicitly granted to it in the Constitution. So here's a question, scholars, I want you to think about. If you are an anti-federalist, are you on the strict side of the equation or the loose side? And conversely, if you're a federalist, are you on the strict side or the loose side? Come ready to talk about it when we have class next time. All right, let's look at the fifth case. Dartmouth College versus Woodward. Settled in 1819. At issue is a charter to a corporation considered to be a contract. And is that beyond the control of the state? Well, Dartmouth College was originally given a corporate charter by the King of England in 1769. In 1779, John Wheelock succeeded his father to the presidency of Dartmouth. From the beginning, Wheelock fought with the Board of Trustees over both religious and political grounds. The president was a Presbyterian who supported the Jeffersonian Republicans, while the Board of Trustees supported the Congregationalists. The Congregationalists supported the Federalist Party. By 1815, the Board of Trustees removed President Wheelock from office. It was at this point where the feud intensified. In 1816, the Jeffersonian Republicans wanted to change the Dartmouth College to the Dartmouth University. The legislation ended up changing the school corporate charter, providing for new positions on the Board of Trustees to be filled by the governor. The old trustees refused to accept these changes. The new trustees promptly removed the old ones. Many of the students and the faculty at the time supported the old trustees. The Dartmouth operation headquarters were moved to the town of Hanover, where they continued to operate as Dartmouth College. The old trustees started to gain control of the school by filing a suit against William Woodward, Secretary-Treasurer of Dartmouth, who was Wheelock's nephew. He sided with the new trustees. The suit was for the recovery of the college charter and seal, college records, and account books. The New Hampshire courts upheld Woodward, and the college appealed to the Supreme Court. The principal issue before the court was whether a state can change the terms and conditions of a corporate charter once it was granted by the state. And this, of course, had implications back to the royal charters during colonial days. Let's take a look at another case. Gibbons versus Ogden, 1824. This is a famous case. What is commerce, and what is the extent of Congress's power to regulate commerce became the critical issue. The state of New York granted monopoly to Robert Livingston and Robert Fulton, the developers of the steamboat, scholars. We've started to talk about steamboats. Okay, here was the issue. They were empowered to issue licenses to those who wish to operate steamboats in New York waters. That's the key, scholars. Ogden turns around and bought a license and later became a partner with Thomas Gibbons, who operated a steamboat between New York and New Jersey. Subsequently, the partners had a falling out, and Gibbons went into business for himself and became competing with Ogden, his former partner. Gibbons secured a federal coasting license. However, only Ogden possessed a license authorized by the state of New York, and argued that Gibbons could not legally operate a steamboat within that state. Ogden went to a New York court and obtained an injunction against Gibbons, forbidding him to operate his steamboat on New York waters. When Gibbons defied the court order, the ship was seized. The case was appealed to the Supreme Court, raising fundamental questions about the Commerce Clause of the Constitution. Commerce Clause of the Constitution, scholars, is Article 1, Section 3. Such pivotal questions concern, for an example, what is the definition of commerce? What is the nature of Congress's power? What role can the states play in regulating commerce? The outcome: it increased the rights of Congress to control commerce. Now let's take a look at another very famous Supreme Court case, Dred Scott versus Sanford, settled by the High Court in 1857. I bet you've heard this case many times, but let's dive a little bit deeper intellectually into the case. First off, the case started in 1846. It was in April the 6th of 1846 when the case went to the Missouri State Court. Dred Scott had filed a claim against his master, Mrs. Emerson. On April the 4th, Mrs. Emerson allegedly hit Dred Scott, his wife, and locked him up and his family. Scott's family lived on a plantation and was locked up by Mrs. Emerson for 12 hours. Scott's original master had been an army doctor. Now, Illinois was a free state. Wisconsin also was a free state. Minnesota was also free. The Missouri Compromise had banned slavery in certain areas. Dred Scott was sold in 1830 to the Emersons. Originally, Dr. Emerson was the owner. When he died, his wife took over the ownership. However, the wife remarried to an abolitionist, and it ended up giving Scott's ownership to her brother John Sanford in New York. As a medical army surgeon, Dr. Emerson would travel to military bases in the West. In some of the places he went, slavery was illegal. Dred Scott thought if slavery was illegal, as soon as he entered those areas, he should be free. Now, Dr. Emerson dies in 1843. Now, when Dred Scott first went to the court the first time against Mrs. Emerson in 1846 in the Missouri State Supreme Court, he lost the case to Mrs. Emerson due to a technicality. After that, Dred Scott tried to go to the U.S. Circuit Court for the District of Missouri. The court accepted jurisdiction and ruled against him. The case then went to the Supreme Court. The court first delayed hearing the case, and then after it heard the case, they delayed publicizing the opinion. A little while after James Buchanan's inauguration, Chief Justice Taney delivered the opinion. It basically said the following: slaves could not sue in court because they were considered property. And of course, this case helped to ignite and precipitate the Civil War. The next case, Plessy versus Ferguson, 1896. What's at issue here? Plessy had gotten on a train. He was 75% white and 25% black. He was sitting in the white railroad car. The conductor kicked him out because he was partially black. He originally argued his case with the district court, and Judge John Ferguson heard the case, and he lost. He appealed to the Supreme Court. And remember, the Supreme Court can decide which cases it wants to hear. So the Supreme Court decided to hear the case. Plessy wanted railroad companies in that state to provide equal riding privileges for passengers of every race. It argued that the state had no right to set segregation policy within its own boundaries. Next case, West Virginia State Board of Education versus Barnett. 1941. At issue, the case was brought to the Supreme Court on appeal from the Federal District Court. Walter Barnett was a Jehovah's Witness, and each public school child had to salute the flag. He had a daughter, which went to a public school. The High Court had to consider the meaning behind Amendment 1 and Amendment 14. And finally, the case was brought to the Supreme Court, and the Supreme Court did rule in favor of Barnett. Keep in mind, scholars, 1941, the United States is becoming involved in World War II, and this becomes, of course, a pivotal issue. So Barnett, the issue here was, the reason why Barnett didn't want his daughter to pledge allegiance to the flag was, it was saying something about God. If they're pledging allegiance to the flag, it's saying that the flag is over G-D or God. And so it violated the First Amendment rights to freedom of religion. And also the rights of citizens, which is Amendment 14. The next case is Brown versus Board of Education, Topeka, Kansas. You probably recognize that one, my dear scholars. That's the one that overturned Plessy versus Ferguson. Case came from the states of Virginia, Alabama, and it ruled on the favor of the doctrine separate but equal. It didn't make its way into the court system until Plessy versus Ferguson. It involved a young girl. Now, Linda Brown was not the only girl. The reason why we say Brown versus Board is alphabetical order. Actually, if you look at the case, it involves many parents who were enraged by it. But because Brown B is the first litigant listed on the docket, it becomes known cleverly enough as Brown versus Board of Education of Topeka, Kansas. So, the outcome of the case, the Supreme Court ruled that separate facilities are inherently unequal because they are separated. Let's take a look at another case. Gideon versus Wainwright. Now, we get a couple cases in here that are really interesting. These are the cases which are really known as the civil rights cases. They start during the height of the civil rights movement. So we're starting in the 60s and into the 70s. So this is 61. At issue here in 1961, Clarence Gideon was charged with breaking and entering into a pool hall. When we say pool as in billiards. He was a poor person. He couldn't afford an attorney and asked the court judge to appoint an attorney. The district court denied him the right to have an attorney in the state of Florida. Gideon tried to defend himself, but he was able to convince the jury that he was not guilty. Gideon lost the case and spent 5 years in jail. While in jail, he spent time researching his rights. He learned that he was entitled to have an attorney. He filed a petition with the Supreme Court using the 14th Amendment as a constitutional provision against Lewis Wainwright, superintendent of prisons,